Good morning, everybody. My name is Nigel Brahams. I'm a partner in the corporate team at Collier Bristow and I also head up our fintech practice. And I'd like to welcome you all to Collier Bristow's Summer Financial Services Update. We've got a packed programme this morning and we've got indeed a very eclectic programme. And first up this morning will be my partner Andrew Granger, who's going to be talking about whistleblowing, a new approach. He will be followed by Maya Lester QC, who is a barrister at Brick Court Chambers and has been known as the Queen of Sanctions. And she'll be talking about UK, EU and US sanctions. And then finally, but not least, I will be in conversation with Temple Melville, CEO of the Scotcoin project. And he'll be talking about launching and operating a cryptocurrency. So I'd also like to mention that we have Q&A online, so if you've got any questions, please post them. We'll probably take the questions at the end unless there's anything particularly sort of moot or urgent. So without further ado, I'd like to hand over to Andrew, who will be speaking about whistleblowing.
Thanks, Nigel, and good morning, everyone. Well, as recent statements from the FCA emphasise, whistleblowing law is more important and more relevant to the modern financial services workplace now than ever. It's also extensive, controversial, technically complex, still evolving, and in some areas, therefore, quite unclear. So my aim this morning, given the very short time available, is to summarise the key principles, provide an outline of those aspects with a specific financial services dimension, and review whether the disclosure of Matt Hancock's extracurricular activities amounted, as the Sun newspaper claims, to whistleblowing. First of all, what is whistleblowing? Well, whistleblowing is essentially the act of an employee or worker who makes a qualifying disclosure in the public interest to someone such as an employer or regulator. In these circumstances, and subject to fulfilling certain criteria, it'll be a protected disclosure, and the whistleblower will be protected from being dismissed or subjected to a detriment on the grounds of that disclosure. The Public Interest Disclosure Act creates two main types of protection for whistleblowers. First, the dismissal of an employee will be automatically unfair if the reason or principal reason for their dismissal is that they've made a protected disclosure. Second, the employees and workers are entitled to compensation if they're subjected to a detriment because they made a protected disclosure. Note that to be a protected disclosure, the disclosure must be a qualifying disclosure. So what is a qualifying disclosure? Qualifying disclosure can be made verbally or in writing, and it's got four main ingredients. It's the disclosure of information, which in the reasonable belief of the person making the disclosure is made in the public interest and relates to one or more of 6 categories of wrongdoing listed in the legislation as relevant failures. So clearly the subject matter of the disclosure is key. There are 6 categories of relevant failure: criminal offences, breaches of legal obligations, miscarriages of justice, dangers to health and safety, damage to the environment, and the deliberate concealing of information about any of the wrongdoings I've just mentioned. The wrongdoing can be past, present, prospective, or merely alleged. It may concern the conduct of the employer or an employee or a third party. It doesn't matter whether it occurs inside or outside the UK. It can be a breach of another country's law. Note also that the disclosure does not have to prove that the information disclosed is true, or that it amounts in law to one of the 6 relevant failures. The disclosure will still be a qualifying disclosure so long as, firstly, the discloser genuinely believes that a relevant failure has occurred or is likely to occur, and secondly, that their belief is objectively reasonable. It doesn't really matter if the belief subsequently turns out to be wrong, or if the facts alleged would not amount in law to a relevant failure. So what turns a qualifying disclosure into a protected disclosure? In order for a qualifying disclosure to be a protected disclosure, it must be made to one of the categories of people listed in the legislation, essentially Section 43 of the Employment Rights Act. The main category is an employer, and tribunals interpret employer widely. For example, where the disclosure has been passed by a junior employee to a more senior employee. The second most important category is a regulator, such as the FCA. Other categories include a person responsible for the random failure, legal advisors, government ministers, a person prescribed by a Secretary of State, or another person, such as a journalist, provided that certain quite strict conditions are met. Note that if the employer has a whistleblowing policy which authorizes disclosure to a third party, for example, an external hotline or a regulator, a disclosure under that procedure is treated as a disclosure to the employer. But making disclosures to third parties can, of course, create conflicts for employees and workers with their contractual obligations. So, can confidentiality be breached by whistleblowing? Well, confidentiality provisions are, of course, standard features of most employment contracts and other workplace contracts. And during employment, employees also have an implied duty of confidentiality as part of their implied duty of good faith, and a more limited implied duty after employment ends. The whistleblower legislation, however, renders contractual terms void insofar as they purport to preclude the making of a protected disclosure. Therefore, where a disclosure of information to someone other than the employer is such as to qualify as a protected disclosure, there can usually be no breach of any express or implied contractual duties. So what are the protections offered? Well, in essence, the disclosure has the right not to be subjected to any detriment, including dismissal, as a result of having made their protected disclosure, and dismissals will be automatically unfair. Employers can also be vicariously liable for detriment caused by their employees, workers, and agents. And a claim can be brought against the person responsible for the detriment, as well as against the employer. So what other duties are relevant? Well, there's no general legal duty on employees to disclose wrongdoing, although the courts have in a number of cases developed the implied term of fidelity so as to impose a duty on those employees with a managerial or supervisory status to report the wrongdoing of others. Also, there's no general duty for an employee to disclose their own wrongdoing. They are likely to owe such a duty where they act as fiduciaries, however. Note that whistleblowing legislation imposes no positive obligations on employers to encourage whistleblowing or to implement a whistleblowing policy. And it does not exonerate employees from acts of misconduct. But regulators usually do impose positive obligations on employers and encourage employees to speak up. So financial services firms, which are subject to regulation by the PRA or the FCA, need to comply with the regulator's rules on whistleblowing. These rules are now contained in the FCA handbook and in the PRA rulebook. They're extensive. I'm not going to list them all here or who they apply to. Affected firms must ensure, and all other firms are well advised to ensure, that their whistleblowing policies meet certain requirements. For example, they must be equipped to handle all types of reportable concerns, not just protected disclosures. They must be accepted from any person, regardless of whether that person is a worker or an employee. They must be able to handle disclosures from people who wish to remain anonymous, They must ensure the effective assessment and escalation of reportable concerns. They must include reasonable measures to ensure that if a reportable concern is made by a whistleblower, no person under the firm's control engages in victimization of that whistleblower. And they must inform all UK-based employees about the FCA and PRA whistleblowing services. They have to keep records of any reportable concerns made by whistleblowers, and they have to have up-to-date written procedures which outline the way in which they comply with whistleblowing rules and guidance. And larger firms are encouraged to create an internal specialist unit to handle disclosures and perform some of the tasks I've just mentioned. And finally, they have to appoint a whistleblower's champion, an individual, preferably a non-executive director, responsible for overseeing all of the firm's whistleblowing arrangements. So what lies ahead? Not so much legislation, but largely the strengthening of guidance and positive steps to promote a culture where the reporting of suspected wrongdoing is encouraged and the protection given by employers to whistleblowers is strengthened. The FCA has been criticised in recent years for not doing enough to protect whistleblowers. And in March this year, the FCA launched a new campaign called In Confidence with Confidence. As its name would suggest, the campaign encourages individuals working in financial services to report potential wrongdoing to the FCA. And it reminds them of the confidentiality processes in place. However, it also reminds firms that culture and governance remain a key priority of the FCA and that its whistleblowing rules require firms to have effective arrangements in place for employees to raise concerns and to guarantee that such concerns are handled appropriately and confidentially. As well as this messaging, the FCA has taken a number of practical steps. It has published materials for firms to use and to share with employees. It's produced a digital toolkit and upgraded its website. It's increased the size and improved the training of its whistleblowing team, introduced the concept of dedicated case managers, and improved case reviews and measures to protect identity. So far, the campaign seems to be having a positive effect, with the number of disclosures being made increasing. And finally, the Hancock scandal and the disclosure by persons unknown of video footage to the Sun newspaper. Was it whistleblowing? Well, let's apply the tests I've just outlined. Is it a disclosure of information? Yes, it contains information that Matt Hancock was having an affair. It's also clear that a recorded form of information can be a disclosure. Is the subject matter of the disclosure a relevant failure? In other words, is it, for example, a criminal offence? Well, arguably, Mr. Hancock is alleged to have breached COVID laws on gatherings, which required that no person may participate in a gathering which consists of 2 or more people and takes place indoors, with certain exceptions. Was it a breach of a legal obligation? Well, potentially. The ministerial code may have been breached, as the code requires ministers are expected to maintain high standards of behaviour and to behave in a way that upholds the highest standards of propriety. They must also ensure that no conflict of interest arises. So the whistleblower may have had a reasonable belief that that had occurred. Was it a deliberate concealing of any of these things? Well, potentially. The fact of the affair was unknown to the public, but reports say it was widely known in the Department of Health. Thirdly, would the whistleblower have had a reasonable belief that the information shows one of the relevant failures? Well, we don't know, but it's highly likely that they would. At a minimum, it would have been easy to deduce that COVID laws had probably been broken. Fourthly, would the whistleblower have had a reasonable belief that the disclosure was in the public interest? Again, we don't know, but probably the revelation of wrongdoing by a key government minister tends to be inherently in the public interest. And finally, is it therefore a protected disclosure? Well, that's where it gets tricky. The disclosure was made to a newspaper, not to an employer, regulator, or government agency. Such a disclosure can still be lawful, provided that certain conditions are met. The whistleblower would need to show that they received no payment for the video and that they feared the information would be covered up, or they would be subject to a detriment if they disclosed it to their employer. So on balance, unless there are exceptional circumstances, the disclosure is probably not protected. It will be interesting to see what happens next. Well, that's all from me. I now hand over to Maya to talk about sanctions.
Thank you very much indeed, Andrew. I wish I had something as exciting to tell you as some good gossip about the Matt Hancock scandal, but I'm afraid my talk is less exciting than that. I'm just going to spend a few minutes giving a sort of update on where we are with financial sanctions, with a particular focus on the financial services sector. And I'd be really pleased to take questions at our Q&A session at the end, because sanctions is one of those fields where people not only have very different levels of knowledge, but also very different interfaces with the world of sanctions, depending on your professional contact with sanctions. So just for those that don't know, we're talking here about very different legal packages of restrictions, some affecting individuals. These are called targeted sanctions, typically asset freezing measures, prohibitions supported often by criminal penalties for breach on making any sorts of funds or resources available to people on lists, but then also less targeted sanctions. So when it comes to certain regimes, you have wholesale prohibitions on doing certain sorts of business or certain transactions with entities in different parts of the world. So they're very wide ranging. They're imposed sometimes by groups of countries acting together. So most obviously the United Nations and the European Union, but also and increasingly by countries acting unilaterally, Canada, America, now the United Kingdom, and many others across the world. And just by way of introduction, this is really, sanctions are in a time of great flux. Sanctions are always, to some extent, in a time of great flux because they are so dependent on world politics and world events. But at the moment, particularly the UK has brand new sanctions regimes, which I will come on to in a minute. The US has a relatively new administration, and US sanctions are by far the most dominant in the world at the moment. And therefore, you know, who is in charge in the United States and the various policies towards key countries like Russia, China, Iran makes a massive difference to sanctions compliance throughout the world. And also, you know, we have world events in flux. So Myanmar, Belarus, what's happening in Iran, Russia, these all have a daily impact on what financial sanctions look like. So briefly starting with the UK, so since the beginning of this year, 2021, at the end of the Brexit transition period, the UK has undergone a sort of sanctions revolution. Why? Because we always used to do sanctions as part of the European Union. Now we're not part of the European Union. We are now doing sanctions alone. That means for the first time, the UK is deciding what its sanctions will look like, who it wants to impose them on, and so on. Now, the UK always had a very prominent role when it came to sanctions, both deciding on what they would look like as really the most active member of the EU when it came to sanctions, but also in other roles that it still performs, namely deciding on exceptions, licenses to sanctions regimes, and also responsibility for investigating whether there's been a breach of sanctions remains part of the sort of national division of labour. And so that still continues, of course, post-Brexit. It does mean that there is a huge amount more guidance on what sanctions mean and how they are interpreted and enforced than there used to be. The European Union, because it was really just a collection of member states without much central competence for sanctions, was very opaque when it came to giving guidance on sanctions. Now every new UK regime comes with its own guidance as to what it means. Those of you familiar with that will think that's either, well, you know, not as helpful as it could be, or more helpful than things were before. You'll have your own views, but at least there is some guidance where there really wasn't before. Now, what does all this mean? Well, certainly it means for those of you engaged in compliance in financial institutions, there is an extra list to screen. So as you know, you're now looking at who are the targets of UK sanctions, as well as UN, EU, and all the others that are applicable. In a sense, that's not an enormous task, because you know, list-based screening is probably the most straightforward kind of screening, although there have been some problems with discrepancies on the two UK lists so far. It will also mean court actions in the United Kingdom for the first time for people challenging their listing on sanctions, and also challenges to licensing and other kinds of national decisions. We don't have any judgments yet, but there will be some coming up, and cases kind of at the early stages going through the pipelines. And there will be some interesting things to say if we you know, are meeting together next year, I suspect, because the courts here will have to examine for the first time the approach of the Foreign and Commonwealth and Development Office to doing sanctions in the UK, as well as the approach of the Office for Financial Sanctions Implementation, part of the Treasury, for implementing them. So there's, again, a sort of division between policy on the FCDO side and licensing and breach investigation on the Treasury OFSI side. Just to wrap up on the UK, you know, what are we seeing so far when it comes to UK sanctions? Well, one very notable thing is a great degree so far of international coordination. So yes, the UK is now separate from the EU, but on the major sanctions rollouts that we've seen so far, Belarus, Myanmar being obvious recent examples, there has been really quite a striking degree of cooperation and coordination, so that packages of sanctions are being rolled out with those kind of international partners. And obviously the EU is now an international partner to the UK, but certainly there seems to be a great deal of interaction. So although we are, as it were, going it alone in policy terms, those conversations are certainly happening internationally. The second, I think, striking thing is that there are now a lot of complex problems, which some of you may be seeing, about which sanctions regimes apply to your particular situation. Because it's not as simple as saying, I'm a UK national or a UK bank, a UK company, and therefore I only need to worry about UK sanctions now, because we're in such an international world that very often financial institutions are having to comply with EU sanctions just as closely as if they were EU-based entities. Why? Because of obvious cross-border exposures of different kinds, EU nationals working in the UK and so on. And also, as before, and as I mentioned at the beginning, compliance with US sanctions remains key if there is any potential exposure to the US, correspondent banking relationships, to a certain extent, extraterritorial secondary sanctions, which we can go into in the Q&A if that would be helpful. But so I guess the second key point is, of course, you can't be narrowly UK focused just because those are the narrowly applicable sanctions in the UK now. Third kind of overall comment on UK sanctions is that to a large extent, UK sanctions track EU sanctions. So there wasn't an enormous change in the substance of what sanctions regimes look like when we left the EU. Largely speaking, the UK sort of copied out EU sanctions with a UK legislative label on them, but not entirely. So there are a number of differences in the detail of what the regimes provide for. There are also differences in who is on the list and who isn't. And some whole regimes, notably the Egypt, Tunisia, Ukraine, stealing state funds regimes, which have been dealt with very differently in a UK context. So you do need to look carefully at the differences, but as an overall matter, the UK certainly took the EU as the kind of starting point. So what's going on meanwhile on the sort of EU side? Well, a lot of people said, you know, what's going to happen when the UK leaves, given that the UK was undoubtedly at the forefront of sanctions policy in the EU. Well, EU sanctions continue. I think other member states, to some extent, have stepped up their sanctions resourcing. The EU, you know, there hasn't been anything radically new or different other than the EU very much adopting the, you know, new sanctions programs, just as other states have done. There has been some quite interesting court-based action. So the quite well-known EU blocking regulation, which seeks to block the effects in the EU of US sanctions of some kinds. There has been, you know, interesting opinion coming from the EU courts, which seem to give that regulation more teeth than some were thinking it might have. And again, we can talk about that in Q&A. Even though there have been hundreds of delisting cases, so people trying to get off sanctions lists over the years, and the case law to some extent is set, there are still some quite interesting and sort of new judgments coming out of the EU on delistings. Most interesting recently, I think, a Court of Justice judgment suggesting that the state of Venezuela, the Republic of Venezuela, can itself bring a case challenging some of the Venezuela sanctions, which is certainly a new approach in the European Court, that a state can bring a challenge to sanctions rather than listed individuals. On the US side, it's interesting. So President Trump, as most of you will know, was a huge user of sanctions, a real ramping up of the use of sanctions as a tool, really, not only of foreign policy, but of sort of economic warfare in the United States, notably in relation to China, particularly with export controls. But President Trump has certainly carried on making active use of sanctions, some that were regarded as you know, highly controversial. So President Trump's sanctions on the International Criminal Court have now been removed. Obviously, we don't know what's going to happen with a sort of, will there be another Iran nuclear deal negotiated? President Biden signaling certainly a different approach to Iran from President Trump. But there hasn't been a sort of wholesale removal of the kind of Trump era sanctions that were imposed. We'll have to see, again, it's sort of early days there. I think it's still, you know, one really striking difference between the US and the EU and UK is the extent to which OFAC, the US sanctions enforcer, is a really much more responsive and engaged and well-resourced agency than you know, any of the other agencies around the world. So it's very different, as many of you will know, dealing with interfacing with US sanctions as compared with sanctions here, simply because of the degree of engagement of the regulator apart from anything else. So finally, three kind of overall trends in terms of recent updates in the world of sanctions that really strike me. First, I've already mentioned, is a kind of real degree of international coordination. Now, interestingly, this doesn't mean, as it sort of used to mean, that the United Nations is the biggest sanctions imposer. They are the sort of least significant sanctions imposer now, even though UN sanctions have worldwide pretty much remit. Why? Because of the presence of China and Russia on the Security Council. They have meant, given the countries where sanctions are likely to be imposed at the moment, that the UN really hasn't done very much on sanctions for a long time. They simply haven't been able to. And so what has happened almost in place of that is international coordination among the unilateral sanctions imposers. So for example, when sanctions were announced and imposed in relation to Myanmar, Burma, when the military junta staged a coup, they were coordinated and imposed at the same time by the US, Canada, and the UK. Belarus imposed in coordination and at the same time by the EU, US, UK, and Canada. So that's quite a remarkable and striking feature. And I think if I'd been talking last year and the year before, what would have characterized sanctions is the degree of international fragmentation. To some extent, I think we're seeing much more coordination than we have done before. Second main feature is the really increasing use of sanctions to deal with what could be seen as criminal justice issues rather than foreign policy issues, human rights and corruption issues. So everyone now has these so-called Magnitsky lists, in other words, sanctions against those who are sort of gross human rights violators around the world. The US, Canada, and now the EU and UK, Australia, other jurisdictions have them. And they are a very sort of in vogue way of imposing sanctions on wrongdoers who are sort of otherwise seen as not being called to account around the world. And these, of course, send a kind of strong signal from the international community that gross levels of human rights violations are not condoned and approved of. There are a number of very controversial things about these lists. One of them is to what extent should they include corruption, or should they focus on human rights violations? And I think that calls into question. So the UK and EU have not so far included corruption. The US and Canada have. What's the issue here? Well, I think one problem with using these lists as a sort of quasi-criminal justice tool is, well, how does that interact with criminal justice? Secondly, you know, the idea of drawing up lists of bad people everywhere is obviously very open-ended. It's very potentially open to misuse, you know, enemies of the state and so on. And that really brings me to the kind of final point I wanted to make, which is, in addition to a high degree of international coordination, we're also now seeing a very significant use of counter sanctions. So, and this, of course, is a big issue with human rights corruption sanctions. If we can impose sanctions on those that we regard as acting contrary to our interests and values, then the same is done to us. And we are seeing lists and sanctions now significantly used by Russia, by China, by Ukraine, by Pakistan, by a number of actors, where, and notably in the press in the last few weeks and months, most obviously, first of all, Russia has an increasing list of what they call undesirable organizations on whom they've imposed sanctions, which really make Russia-related operations impossible, including some pretty significant international NGOs. On the China side, China now has its own version of the blocking regulation. In other words, you know, if we can try and block the effects of US sanctions on Iran because we had a divergent policy with the US, China's doing the same, trying to do the same now with a number of Western sanctions. And also, you know, very controversially in my area, sanctions on barristers. A number of you may have seen that a barristers' chambers in its entirety was sanctioned because of a legal opinion that was drafted by some members of chambers relating to the Uyghur mistreatment of the Uyghurs. And so there are real issues now around the world with kind of tit for tat sanctions and how that interacts with the overall legal landscape. So that's the end of my time. I'll leave it there, but very much welcome questions and discussion.
Thank you very much, Maya. That was extremely interesting. It's really good to find an area where law meets politics. I suppose to a certain extent, Andrew's talk also law meets politics, but particularly with sanctions, that's really fascinating. And I think we've got some questions, but we'll cover those at the end in the Q&A. So now, moving swiftly on, I will be in conversation with Temple Melville, who is the CEO of the Scotcoin project. The Scotcoin is the only cryptocurrency north of the border, and has an interest, as Temple has an interesting tale to tell about it. So we will be in conversation now, and so it's over to me and Temple. So this is going to be something of a fireside chat without the fireside. So Temple, first of all, welcome to our financial services update, and it's very good to see you.
Thank you.
And before we go into the depths of Scotcoin, I was wondering if you could just give us a 2-minute resume of what you did in your career before you discovered Scotcoin, so we could get a sense of where you're going.
Yes, I think my career, if there is such a thing, it began really at the LSE, and I'm very proud of the fact I was at the LSE with people like Danny Cohn-Bendit and Tariq Ali and Mick Jagger, which will tell you how incredibly ancient I really am. And at that period, it was basically shut for most of the time I was there, which was in one way a good thing. And I've always maintained that the only reason they gave me a degree at all was because they couldn't see me on any of the pictures or footage or anything, breaking down doors or doing whatever. So that was where it all began. But while I was there, I was very involved with, although I did economics, I was very involved with mathematics. And one of the things that I find very interesting is that when I was there, the first or the last thing that I was doing in mathematics was a thing called sets. And sets are basically the building blocks of computing and so on. And I'm staggered to discover that my grandson, who's only 9, is already doing sets. So that'll show you how we've moved on. So anyway, I finished up at the LSE, and I was asked to go and look after an uncle who lived in Glasgow and was ill. And I went there, and he was in fact the MD of a fruit business in the Glasgow fruit market. And I sort of set up my stall there and made things work for the company, which was good. And I enjoyed it very much. I've really enjoyed being in the fruit business. A great lot of bonhomie and good fun and so on.
And you became a property developer after that?
Well, while I was doing that, I started in property, as one does with flats and so on, and progressed on to shops, offices, industrial warehouses, and so on and so on. And that was really what the bulk of my business life has been.
And so then, sort of later in your career, you discovered fintech and crypto. What piqued your interest in that?
Well, it started really with the interest with cryptography, because the basis of blockchain and Bitcoin and so on is cryptography, very strong cryptography. And I'm probably one of the few people who's actually read the white paper that Satoshi Nakamoto put out in 2009. And the thing that struck me immediately was that although he was really talking about what's called the double spend problem, which is to do with financial transactions, the actual use of the blockchain was very significantly greater than just transferring money around the place.
Absolutely.
And
so tell us a bit about how you got how Scotcoin relates to sort of the wider Bitcoin and blockchain, and where Scotcoin came from, because you weren't the original founder of Scotcoin, were you?
No, I wasn't. It was a chap called Derek Nisbet, who was a Scottish national independence supporter. He decided that should the referendum in 2014 be won, Scotland would require some form of exchange in terms of keeping a track of things. Should, for example, the British Treasury decide that they couldn't use pounds anymore and so on.
So Scotcoin could have been the national currency of Scotland.
Well, it might. I suppose it might have been, and I suppose it might still be, but I think it's unlikely. But anyway, so of course the referendum was lost. Derek was just a one-man band. He kind of lost interest. And one day I was talking with a friend of mine, David Lowe, who's world famous for having rescued Celtic with Fergus McCann. And he said, did I know anything about cryptocurrency? And I knew a little bit. And he immediately said, well, he wanted to do a Scottish coin for use of currency, etc., etc. And I said, well, there is one. It's called Scotcoin. And he immediately said, that's a brilliant name. And it is. It's a great name.
And so when you bought Scotcoin in 2015, didn't you, just after the referendum? And
Yes.
I think you bought Scotcoin with 150 bitcoins.
100, that's exactly right. There was 150 Bitcoin, which I think at the time were around $200. I think we worked out it was, yeah, about $200. And of course, the one thing I do know is that Derek Nisbet almost immediately sold them. So he didn't benefit as much as he might have done. I think everybody who's ever bought Bitcoin has almost immediately made a short profit out of them without hanging on, as most people don't.
And so when you took over Scotcoin, I think there were only 500 holders. But you've
That's true. There were in fact there were probably less than 500. Some of them were duplicates and so on. But that we started sort of late 2015, early 2016 to expand, basically to expand knowledge of Bitcoin and the blockchain. Because the blockchain, the one thing that everybody needs to take away from this talk, if nothing else, is that the Bitcoin itself and blockchain are two entirely different things. Bitcoin could not exist without the blockchain, but the blockchain could quite happily exist without Bitcoin. And so you have to think of blockchain as being an enabling technology rather than a be all and end all to Bitcoin itself.
Absolutely. No, it's something which is an area which I specialize in. So I know that blockchains have huge potential use in a very wide range of areas, including property management, financial services, healthcare, I mean, you name it, international trade.
Yep.
And it's only going to grow. So you kind of pivoted Scotcoin from being the sort of alternative currency post successful referendum into something completely different. Do you want to tell us all about what Scotcoin does now?
Well, we started from the point that I think at the time we were first involved, there was something like about 2,000 cryptocurrencies. There's now something like 10,000, and that doesn't include the several thousand that have completely disappeared in the intervening time. And, you know, rather than being a Me Too, we had to have a USP. And we took the decision that I had been aware of a cryptocurrency from the 1930s called WIR, W-I-R, in Switzerland, which still exists to this day and has a very positive impact on the Swiss economy. They have something like 70,000 businesses that accept it. They have something like 700,000 people who use it. And it turns over about 6 or 7 billion Swiss francs a year. So that's a significant amount. And our thought was, well, if we could bring something similar to Scotland, that would have a significant effect on the well-being of people in Scotland.
And so you've got charitable, there is a charitable aim to Scotcoin, isn't there? So
absolutely, yes. I mean, we work particularly with homeless charities. The most recent thing we did was one of the other things is, of course, we should all be much greener than we are. And one of the areas that are very poor in terms of greenness is, in fact, fashion industry. And they're forever throwing stuff away and burning it and burying it and doing all sorts of things with it. And what we've done is we've kind of stepped in and we take chunks of clothing. The most recent was, in fact, tracksuits from a manufacturer down in, believe it or not, in Essex. We paid them in Scotcoin, and we then moved forward, took it up to Scotland and gave it to people called Emmaus who work with the homeless. And they, you can see lots of people running around Glasgow at the moment wearing these very nice tracksuits.
And so if I was to give you a load of tracksuits and you would give me a lot of Scotcoin, what would I be able to do with that Scotcoin? What could I buy with it?
Well, it would depend what you wanted to do. There is an ongoing process of adding people to our, what we call our merchants. And I mean, for example, the most recent people to add are, in fact, art gallery in Glasgow and Edinburgh. You can go into them and you can buy a painting or a piece of art, or in fact other things, because they have other things there as well for Scotcoin. But the be all and end all is possibly that people would want to turn that into fiat currency, and that is our current runway we're on, which is towards an IEO later in this year.
Yes, so that would potentially be revolutionary for Scotcoin, wouldn't it? Because you then, at the moment, you're effectively a sort of currency in its own right, but without a natural conversion rate to pounds sterling or euros or dollars. Whereas if you get on exchange, which is your plan, then suddenly there will be a real price for Scotcoin, and you can become more of a real exchange token or a real exchange currency.
That's right. I mean, it's quite interesting. I mean, I think I'm right in saying that when we started this journey, we were paying something like $40, or we paid about $40 a million for Scotcoin. And the most recent price that we were dealing at was effectively £16,000 per million. So that's been a very good journey in terms of helping people, because it means that those who came in at an early stage and who received Scotcoin in the early stages have been able to do good things with it.
Yeah, so Scotcoin has both a charitable and a commercial impact, it seems.
I would say so far it's really only had a charitable impact. I mean, one of the things we do is we have people who are prepared to donate to various charities, and as a thank you, they get Scotcoin for doing that. They then tend to transfer it to other people to widen the number of people involved in the ecosystem, and that's been a very successful initiative.
But it strikes me that if you get on exchange, you could hugely expand your reach.
Absolutely. Well, we already have, in fact, I believe we've got 54 countries in which Scotcoin is held. I'm practically certain it's all part of the Scottish diaspora, but that's none the worse for that. And we would certainly hope that we would have a much wider reach when the time comes.
Okay, finally, we're just going to talk about the regulatory impact on Scotcoin, which is something we've been working on together. And we've been recently considering the impact of the changes to the money laundering regulations on Scotcoin, and the question of whether or not, as just by way of background to those on the call, so the FCA has been made the anti-money laundering supervisor for crypto assets, and under changes to the money laundering regulations brought in 2019, the activities under scope have been expanded to include operating the exchange in crypto assets and operating a crypto asset wallet. And we had a good think about whether Scotcoin was undertaking any of these activities, because if you had been, you would need to be registered with the FCA, and you indeed, unlike many crypto businesses, applied in time to be registered. And we had a good think about whether or not Scotcoin was a crypto asset, which I think we came to the conclusion that it is a crypto asset, because a crypto asset is an asset which effectively exists on a blockchain. In your case, it's an ERC20 token. I mean, it's on the Ethereum blockchain. But we came to the conclusion that you were not actually undertaking the activities of operating an exchange or arranging transactions, because effectively this is effectively a sort of over-the-counter process at the moment. And when you go on exchange, hopefully that exchange will take that responsibility over from you. And we discussed this actually, and because the laws are not that precise, we end up having quite a detailed conversation with the FCA on this point. And we were in this odd situation where the FCA were trying to persuade us that you were not under their ambit, and we were trying to persuade them actually, yes, you might be, which is very, very counterintuitive. I think that the background to that being that the FCA when they launched this process, they assumed a small number of people were going to apply. The reality was they got a flood of applicants to be registered with them, and they're now looking to find ways to remove some of them from the list. And in fact, in your case, I think we genuinely and fairly comfortably took the position that you didn't need to be registered with them.
Yeah. I think the most interesting thing about that is that, in fact, long before we even applied to the FCA, we already conducting KYC and AML on people who applied to us to buy Scotcoin. And of course, the point is that we can register them, that's no problem at all. But once it's out of our hands and in a third party's hands, what they do with it is entirely theirs business, and it's not regulated at all, because, you know, if I sell to you, you can sell to a third party, it could be anybody.
Absolutely. Well, effectively what you are is an exchange token. So the FCA came up with 3 different categories of token: exchange tokens, utility tokens, and security tokens. An exchange token is like a Bitcoin. It's something which is used like money. A utility token provides utility, and to a degree you may have some utility. And then the third one is a security token, which a token which mirrors the characteristics of a bond or equity, which you certainly don't have. And that was actually quite helpful in terms of taking the view that you probably don't need to be regulated or authorized in order to do this. We've also considered whether or not you might be issuing e-money, but we don't think you are at this stage. But of course, that's something we need to keep an eye on. If you get on exchange to become widely traded and your scope expands massively, we may have to take a view as Scotcoin becomes more and more successful.
Well, that would be both a nice thing and a bad thing, I suppose. But I mean, we just have to go with whatever the regulations come up with. And we've long said, I mean, long before anything, people, when we started saying, well, we're going to do KYC and AML, which I guess was sort of late 2015, early 2016, we were absolutely lambasted by all the crypto freebie currency people, because they said that's against all the ethos of the whole thing. And we said, well, no, it's going to come. It must come. It has to come.
Well, you were very prescient. So thank you very much, Temple. That was extremely interesting.
Thank you.
And now we're going to move on to the Q&A. And Darren, if you can put all the speakers on screen again, in gallery view. I can see we've got a few questions, and I'm going to read them out. We've also got one question in the chat. So in order the questions have been sent to us, they mostly seem to be for you, Maya. So if anybody has any other questions for any of the other speakers, please do fire them in. So the first question is from Robin Stevens. Robin asked if we are prevented from providing professional services to entities in Iran, subject to AML considerations.
I mean, so on Iran, the general answer to that is no. I mean, the UK restrictions on sanctions on Iran have considerably rolled back since the nuclear deal was agreed. So there aren't the kind of overall prohibitions that there were before. There are still list-based sanctions. So you have to be really careful who you're dealing with in Iran in terms of what, who the services are benefiting. It's also worth saying, though, that depending on the nature of your business, you may also have to look at US sanctions on Iran, which are very extensive still, or again. So you have to take care, particularly in terms of end users and whether other sanctions regimes kick in. But there isn't a general prohibition on professional services to Iran.
And does it make a difference if somebody's selling, say, commodities or goods to Iran rather than professional services?
I mean, there isn't a general prohibition on commodities to Iran, but there are, some dual use type restrictions, and the devil is kind of in the detail. But again, there isn't a broad prohibition on any kind of service.
So I suppose that's actually quite a good example of somewhere where different countries take different approaches.
Absolutely, and Iran is, there has been a lot of. Iran is the most sort of divergent, because at the moment the state of play is there is still a nuclear deal, and therefore the EU and UK side of the lifting of sanctions when the nuclear deal was agreed under President Obama still has effect, and we're all desperately trying to find ways of propping up that deal. But because Trump pulled the US out of the nuclear deal, they then reimposed some of the US sanctions on Iran that had previously been lifted. And so, yes, there's a great clash at the moment between the US, which still very significantly restricts business with Iran, and here, which does to a much lesser extent. But you can imagine that creates great legal complications, because a lot of people here have to be careful about US sanctions, not least because the Iranian sanctions program in the US is subject to these so-called secondary sanctions, which means that in the EU, even if you don't yourself do business so the problem with secondary sanctions is even if there's no US nexus at all, so there's no use of US persons, no US dollars, you still can't do business with Iran if you are dealing with a US SDN, in other words, someone sanctioned by the US. So that's the so-called extraterritorial effect of US sanctions, which really still strikes fear into the hearts of anyone dealing with any sector that's Iran facing. So ironically, it's sort of the sanctions regime that doesn't strictly apply that I would say still has most practical effect here.
That's interesting, because of the worldwide remit of the US.
Exactly. It's the
Okay.
power of the dollar. I mean, it's particularly true where dollars are involved.
No, it's interesting. I've got a client who wants to deal with Iran at the moment. They're not a US entity, but they're terrified of the potential sort of ramifications for them if they do, because they've got a US backer.
Right. Yeah. Yeah.
Moving on, we have a question from Theodosia Papazikou. Could you elaborate on the EU blocking regulation, including what kind of steps need to be taken by a company that has also exposed to the USA market in order to avoid as much as possible to be caught by the USA law enforcing machinery?
I mean, this is sort of related to the question before. I mean, I guess there's two bits to that question. I mean, one, you know, very much along the lines we were just discussing, how can you make yourself as free of US sanctions risk as possible? I mean, one obvious thing is don't use US persons, US nationals, don't do any business in the US, and don't use the US dollar. Now, even if you kind of do all those things, you're still at some risk from these so-called secondary sanctions. So don't deal with US SDNs. I mean, that would be the kind of best advice of a very general nature. The blocking regulation is actually quite limited. So this applies to some US sanctions. That's the sort of so-called extraterritorial sanctions, or the extraterritorial effect of some of the US sanctions programs relating to Iran, Libya, and Cuba. I mean, its effect is a bit less far-reaching, I think, than some think. But what it basically does is make it unlawful in the EU to comply with US sanctions in various different ways. So it makes it unlawful to comply with any requirement or prohibition based on or resulting from some US sanctions laws that are kind of listed in the regulation. And the puzzle for the European Court and for operators is, what does that mean? It also says we won't give effect in the EU to judgments or decisions resulting from those sanctions, and it gives a right to damages, and according to the European Court, an injunction. So that's kind of where the blocking regulation fits in. I say we because there's also a UK version of the EU blocking regulation post-Brexit. I think it's probably not really for Q&A kind of exactly what effect that might have, but it certainly means that, you know, the most basic thing it means for operators is if business is being wound up or stopped in Iran, operators are not citing US sanctions on Iran as the reason for stopping, because they don't want claims against them to say, well, you are giving effect in the EU to those US sanctions by acting on those sanctions, and therefore you're in breach of the blocking regulation.
I've got a couple of more questions from my partner, Robin Henry, who specializes in banking disputes, and actually they're related to what you've been talking about. And they're related to each other actually as well. He asked, to what extent will the trend towards international coordination on sanctions be counteracted by differences in EU and UK guidance and detailed regulations? And his second question is around the UK's loss of influence over the EU's direction on sanctions, and will that create greater divergence over time? And he particularly references Russia.
Yeah, I mean, good questions. I think that there will be international coordination on sanctions, and that's happening, and that's probably a good thing. But that is broad coordination on some regimes where there is international foreign policy alignment, so on Belarus and Myanmar. And there is also coordination to some extent on the timing, no doubt partly for symbolic reasons, but that doesn't mean that identical financial sanctions have been imposed. And actually Belarus is a good example, because the EU has imposed sort of sectoral sanctions. In other words, sanctions a bit like the Russia sanctions on state-owned companies in Belarus, restrictions on certain kinds of transaction that weren't a feature or haven't been so far, for example, of UK sanctions. And so I don't think the fact that there will be a difference in the regulations and the guidance will mean that there won't be international coordination. There will be, it's just the coordination doesn't mean that they're identical packages. Now, on the loss of the UK's influence, I mean, I'm not sure about this because obviously I'm not in government, but my guess is that, yes, the UK is no longer around the table in the EU, obviously, but that doesn't mean it doesn't have influence. And I suspect that conversations are still happening, possibly in a more bilateral setting. The UK, for the time being, still has some good relations with individual member states when it comes to sanctions and foreign policy. And also the UK has been pretty active in imposing sanctions, and doing so in the coordination with the EU and other states where it is in its foreign policy interest to do so. And I think that's the thing, where there is no legal requirement anymore to act together, but the UK is still very active in sanctions. It's still very well resourced, and increasingly so when it comes to sanctions compared with other member states. So I don't think the UK will lose influence at all, but I think it just loses that requirement for unanimous decision making in the EU. So will it cause greater divergence? Well, I suppose by definition it will, because the UK is already doing things a bit differently from the EU. What about Russia? Well, the UK doesn't have to reach agreement with 27 other member states, including those with incredibly divergent attitudes to Russia. So yes, I suppose the likelihood is that we would be able to impose tougher sanctions on Russia if we wish to do so than the EU. But will we wish to do so is the question, particularly given that there is such a significant amount of Russian money in the United Kingdom in financial services. Do we want to tip that playing field to make it less level and have a risk of business flight? These are all questions that government and policymakers have to think about.
As we discussed earlier, it is really sanctions is where politics meets.
Exactly right. And it's legal instruments, but born of foreign policy and politics.
But in order to spare Maya's voice for a moment, we've got a question for Temple, so I'm just going to shoot down to that from Jin Sun. Would you consider listing Scotcoin on Binance, and how do you look at the various exchanges? Will Scotland promote more measures to attract global crypto investors or operators?
Yes, I would be perfectly happy for Scotcoin to go on Binance, and in particular, I'd be very happy indeed if it went on Coinbase. The problem is that until you have a certain level of trade backwards and forwards, and you have a certain number of people involved, both those exchanges are pretty, don't really want to know you. So our plan, which has been mirrored by others, is to move on to what I would describe as a tier 2 or tier 1.5 exchange, build up the numbers of holders and so on, and then move along to Binance or Coinbase. Interestingly, I've been involved with another coin. I've been helping them, very good coin, Agri10X it's called, doing wonderful things with India. And they're just about to list on both Binance and Coinbase, but the process has been staggeringly difficult, is the only way I can describe it. And they have millions of holders already, so they're already working on it. And
any difference particular between Binance and Coinbase, which is the more difficult, or?
Binance is a bit weird because it technically doesn't actually have a situation anywhere where it is registered. It's sort of out in the ether there somewhere, and you've probably read about people stopping them trading in various countries and so on.
in the UK, or
in the UK as well. Yes,
that's. I mean, just to clarify on that point, that was just Binance's UK.
Binance Marketing Limiting or something.
Binance Finance Limited, and it's just in the UK, and it was just in relation to crypto derivatives, not in relation to the underlying cryptos.
Yeah, that's right.
The reason for that is that the crypto derivatives are actually regulated instruments under the regulated activity order of the SMA.
I mean, Coinbase is a much more straightforward situation. They're an American registered company. They're on the NASDAQ. They have their own rules and regulations, and it's obviously governed to a certain extent by the SEC. And therefore, it's quite clear what the issues are that you have to deal with, as opposed to Binance, where it's not necessarily quite so clear.
Okay, I think we've got time just for one last question, as I'm conscious that we're a little bit over time. And this one is from John Binns to Maya. How much use would you predict the government will make of the Magnitsky-style sanctions? On the face of the scope is very broad, especially on the corruption side. And then we'll better wind up after that.
Yeah, no, thank you for that, John. And actually, there are some other questions about the sort of anti-corruption human rights sanctions. And I think I may have misspoken in what I may have said, that the UK and the EU don't have sanctions against corruption, but of course the UK does, the EU doesn't, at least yet. But they both have sanctions for gross violations of human rights. I mean, it's hard to say. It is a very broad tool. On the US side, as you know, the US makes massive use of its corruption and human rights sanctions. Query how effective they are, if by effectiveness you mean, do they actually freeze a lot of assets in the UK? Because that depends entirely on who the person is and whether they have assets in the UK, obviously, whether they do business here. But I think certainly if their effectiveness is in symbol sending, then they are powerful. It's really hard to say. I suspect the UK, may be weighing up the sort of pros and cons of using these sorts of sanctions, and in particular, how far it is appropriate to use a foreign policy tool of that kind to kind of draw up lists of miscreants of various different kinds, and also the degree to which they will require a kind of UK nexus. So is this simply the UK going and being the kind of police officer around the world, or will it be only, corruption and human rights violations that have some UK impact? We'll have to see. They'll also be mindful of court reviews. And to answer another question related in the Q&A, I mean, we haven't got any experience yet of UK judgments because they just simply haven't gone through the court system yet. But obviously the government will be mindful of judicial review. I mean, the other thing to say just finally is that the standards are very different here. So if you are being accused of corruption or some sort of serious criminal human rights violation, obviously if you were in a national court, you would be subject to serious safeguards and, trial perhaps beyond reasonable doubt. Sanctions have an incredibly low evidential threshold. All it takes to get someone on one of these lists is reasonable grounds to suspect that they have done X, Y, or Z. That's a very low threshold. And the sorts of evidence that's normally used is kind of he said, she said, hearsay evidence, NGO reports, sometimes of a very robust nature, but sometimes much less so. So I think the government will also be wary about far-reaching restrictions on people without those sorts of safeguards. And also a point I made earlier, tit-for-tat sanctions, right? Once we start drawing up lists, and Russia's already started doing this, there will be counter lists as well. So lots of policy factors to consider.
Thank you very much, Maya. Thank you very much, everybody. Just to say, I think that's the end of our seminar today, and I want to thank everybody, thank the speakers very much. So thank you, Andrew, thank you, Maya, thank you, Temple. Thank you all in the audience for joining us. Thank you for all your questions. Please join us again at our next financial services update, which will be in the autumn. And in the meantime, if you have any questions for any of us, please do not hesitate to get in touch. And so that's goodbye from all of us. Thank you very much.